Welcome, everybody, to Law Day. Law Day at Dartmouth is a little interesting. Law Day is celebrated on May 1st every year to celebrate the role of law in society and to cultivate a deeper understanding of the legal profession. You might have noticed that it is not May 1st. So Dartmouth does things a little differently. We start our talks at 4:30, really at 4:35. Today, our Law Day speaker is Stephen Bright. So I'm going to give you just a little bit of information about the Law Day events and an advertisement for tomorrow as well, and then introduce our speaker. So the Law Day celebration at Dartmouth is supported by the Dartmouth Lawyers Association and planned by the Dartmouth Legal Studies Faculty Group and the DLA, the Dartmouth Lawyers Association. We want to acknowledge the president of the DLA, Howard Morse, who is here today, and Hal Rabner, who established several of the named lectures that we offer, who unfortunately was planning to be here today but couldn't be here this time. I want to invite you all to join us for the Law Day panel tomorrow. The title of the panel is Rethinking Capital Punishment, Recent Challenges, and the panel will include Stephen Bright, today's Volk lecturer, Christopher Keating, who's the executive director of the New Hampshire Judicial Council, David Runke, attorney at Runke and Barrett, and Alexander Runlet at Barzy Flores, and the moderator of that panel will be Sam Braverman, who is a partner at Fasulo, Braverman, and DiMaggio LLP. Almost all of these people are Dartmouth alums, another plus. And that panel is also co-sponsored by the Dartmouth Lawyers Association and the Dartmouth Legal Studies Faculty Group. Okay, so for today, I'm happy to have you all here at the Volk Lecture. The lecture series was established in 2004 by friends and colleagues honoring Stephen Volk, class of 57, who was chairman of Credit Suisse First Boston and formerly from Shearman and Sterling. Previous Volk lecturers include Kenji Yoshino, Martha Minow, Michael McConnell, Don Verrilli, Sarah Weddington, and Heather Gerken. All of these are very accomplished and well-known legal thinkers, as is our Volk lecturer for this year, Stephen Bright. Stephen Bright is president and senior counsel at the Southern Center for Human Rights and lecturer at Yale Law School. He's represented poor people in the legal system for more than 40 years as a legal services attorney, public defender, and an attorney with a public interest law project. His work focuses on legal representation for poor people accused of crimes, capital punishment, human rights violations in prisons and jails, and judicial independence. He has argued capital cases before juries in 3 states, in state and federal appellate courts, and in 3 cases before the United States Supreme Court. He joined the Southern Center for Human Rights in Atlanta as its director in 1982 and served in that capacity for 23 years before becoming its president and senior counsel in 2006, the position he still holds today. Bright has taught at Yale Law School since 1993 and at a number of other law schools, including Harvard, Georgetown, Emory, and Georgia. The Daily Report, Georgia's legal newspaper, named him Newsmaker of the Year in 2003 for his contribution to bringing about creation of a public defender system in Georgia, and he received the American Bar Association's Thurgood Marshall Award in 1998. Today he is going to talk to us about capital punishment, and the title of his lecture is Rigged: When Race and Poverty Determine Outcomes in Death Penalty and Other Criminal Cases. So please join me in welcoming Stephen Bright.
Thank you, Adina. Thanks so much. And I want to thank everybody, including Joanne Needham, and for such a warm welcome that I've had here. I've been so excited about coming to Dartmouth. I've never been here before, but I've known a lot of people who have been here. Alexander Runlet, who's going to be on the panel tomorrow. Stand up, Alex, stand up. Alex was a lawyer in our office. He went to the University of Pennsylvania Law School. He came and was a lawyer. We worked very closely together for a number of years. He's one of the most outstanding human beings and lawyers that I've known. Then we got a call. In fact, I think Alex was in charge of our intern program, weren't you? When we got a call from a young woman named Mattia Holly, who was a student here, looking for an internship. And just all of you students, I want you to know this, the very best internship you can do is at the Southern Center for Human Rights, okay? And Alex called me and said we had this young woman named Mattia Holly who wanted to come do an internship with us, and she was from Dartmouth. And of course I knew Alex was from Dartmouth. I said, you know, Alex, that's sort of a party school, isn't it? I said, I don't know if we really want to take somebody, obviously, just kidding. She came, I don't know how she got an internship this long, but she came in November and stayed all the way until the following May, working with us on our efforts to improve the right to counsel for poor people accused of crimes in Georgia. There were many memorable things that she did, but one of the most memorable, and it sort of tells you the kind of problems we were dealing with, was she was visiting a jail in rural Georgia, and some of the prisoners there told her that she should go meet this gentleman named Samuel Moore, who had been in the jail for a long time, and nobody really knew what he was doing there. And so she went and interviewed Mr. Moore, and she found out that he had been arrested 13 months earlier on the high crime of loitering. Loitering, you've heard of driving while black. Loitering is standing around while black. I mean, he was just standing around, he was arrested, he was put in jail, and in 13 months, 2 Christmases in jail, he never saw a judge, he never saw a lawyer. He had no idea whether he was ever going to get out of there. So Atiyah went to the clerk's office to find out what was going on with Mr. Moore, and it turned out that the charges had actually been dismissed 4 months earlier. But nobody had bothered. You talk about throwaway people. You talk about people who are just discarded by society. Nobody had cared enough about Mr. Moore to call over to the jail and say, you don't have a legal basis for holding this man. And Atiyah got him out. This Dartmouth intern got him out of jail, walked him out of jail that afternoon. And we use that as one of the examples of what terrible shape the right to counsel was, that a person who's arrested has a right to have a lawyer who's going to try to get them out on bond, a lawyer who's going to look after them, make sure they promptly get before a judge, and a lawyer who's certainly going to make sure that anybody charged with such a minor crime, actually loitering is not really a crime. It's just one of these many things that we have on the books today that make it possible for the police to arrest anybody they want to. The Atlanta Journal-Constitution ran a color picture of Mr. Moore on the front page and told his story and about how this Dartmouth intern got him out. At the end of our internship, we were so impressed with Atiyah that we hired her as an investigator. She worked for about 4 or 5 years with us, investigating cases, working on finding other Samuel Moores, finding people who were lost in jail. At the end of that time, she went to Boalt Hall, to the University of California, at Berkeley Law School, one of the best law schools in this country. And now she's in about her 5th or 6th year as a lawyer with us, because as soon as she graduated from law school, she came back to the Southern Center. So that's been our great Dartmouth experience with Atiyah Holly. She's a great lawyer, and I'm eternally grateful to whoever recommended it for her to come. Any of the rest of you that are interested, please let us know. I appreciate the opportunity to be here in this discussion you're having about capital punishment. I think capital punishment is one of the great moral issues of our day. The Constitutional Court of South Africa, when it considered the death penalty there, unanimously held that it was unconstitutional. And they said, in their opinion, in a society, we're a society that is trying to move from hatred to understanding, from vengeance to reconciliation. And in the kind of society that we're building here in South Africa, there's no place for the death penalty. It was unanimous opinion. I think the death penalty says a lot about what kind of society we want to have, what kind of people we want to be. The death penalty, Arthur Goldberg, Justice of the Supreme Court, among many other positions, once said that tying down and putting down a human being has got to be the greatest degradation of the human personality imaginable. But it's more than that. it's not only degrading to the person who's tied down and put down, it's degrading to the society that does it. It coarsens the society. It talks about how the society, it speaks volumes about how the society deals with its problems. And in the United States, the death penalty has been tied from the outset to race. And I want to talk a little bit about that history before I talk about how the system today, and much of what I'm going to say about the system being rigged on the basis of race and poverty doesn't just apply to death penalty cases. It applies to every kind of case that comes into the criminal justice system. But I will get there. There's never really been any reconciliation of the brutal history of slavery, convict leasing, lynchings, the chain gang, and now mass incarceration in the United States today, and what they say about our society and our justice system. There are few encouraging signs. I think today there's bipartisan, in a time of the greatest polarization imaginable politically, there seems to be bipartisan agreement that the criminal justice system does not work, that it's convicting innocent people, it's sending people away for too long, it's dealing with health problems as criminal problems. The criminal justice system has become the great dumping ground for people who are homeless, for people who are addicted to drugs, for people who have all sorts of problems. Not that they're committing crimes, but that they're just the abandoned people in our society, and that we can't do any better for them than to put them in these cages that we have all over the country. But we are getting there. We're reminded today that Black lives matter. And I think it's important to go back and talk for just a minute about how little Black lives have mattered in the criminal justice system. Of course, the death penalty is tied and goes right back to the very start, slavery. When you had a captive population, when you had people who were already in slavery, prison didn't really offer much of a form of punishment. So the death penalty was essential to maintaining the institution of slavery. If you look at why 85% of the executions and 85% of the death sentences in this country today come from the states of the old Confederacy, from Texas and Georgia and Louisiana and so forth, it's because of slavery. It's because that's where, when the northern states were either abolishing the death penalty, and Michigan abolished the death penalty in 1843, and some other states did before the Civil War, some of the other northern states were at least limiting the death penalty to just homicide cases, to just murder cases, but no other kind. But in Louisiana, you could get the death penalty for distributing leaflets. You could get the death penalty for almost, well, if you were a black man who looked the wrong way at a white woman, if you did not get lynched, you would get the death penalty. The death penalty was imposed for all kinds of crimes, minor and major, in order to maintain this institution of slavery up until it was finally abolished. But what I think many people don't appreciate is that slavery didn't end with the Civil War. A lot of folk think that it did. But almost immediately, the criminal justice system in the South went into action to maintain slavery through convict leasing. That people would be arrested, often on very de minimis charges, and then would be housed, and this is convict leasing in Alabama. These, you can see those wagons there. That's where these people lived, that's where they ate, that's where they slept. And when they weren't in there, they were out working for the coal mines around Birmingham, for the turpentine camps, for the railroads. They were basically no better off than if they had been, they were probably worse off. David Oshinsky wrote a book called Worse Than Slavery, because he said with slaves you at least had a property interest in preserving your property. But with convict leasing, you actually had disposable people. You could work people to death and then just call the sheriff and get some more and lease them. this is another view of the housing, the way people died often of disease, because of course there was no care for people if they had diseases. They had no kind of diet whatsoever, just enough to keep them alive. This was building a railroad in North Carolina. This is in 1878. Over 500 convicts were involved in the Western North Carolina Railroad. 125 of them died while the railroad was being constructed due to accidents and maladies and other people. These were disposable people, as I said. As Oshinsky writes in his book, convict leasing was designed for blacks and not white convicts. And the South's economic development, and to a large extent the nation's economic development, in terms of the railroads and the steel industry and so forth, can be traced to the blood of its prisoners. If the Rockefellers or anybody else made a lot of money on U.S. steel, you can trace it directly to convict leasing and to the mining that went on around Birmingham, Alabama. Oshinsky's book points out, he focused mostly on Mississippi, but he also talked about the other southern states, that you could send a black to prison for almost any reason, but it was very difficult to get a white person there. Whites usually sent fellow whites to prison only for really serious crimes and not for much time. And this is the history of the criminal justice system that I think we've never run out of. That the criminal justice system allowed whites to exploit blacks without any legal limit, to withhold the most basic rights and safeguards and treat them in this sort of paternal way. And as he said, it turned the criminal justice system into a corrupt and capricious entity, utterly undeserving of respect. His book, the one there, Worse Than Slavery, Douglas Blackman's book, Slavery by Another Name. Blackman's book is about convict leasing in Alabama. Alabama maintained slavery until World War II. That while a lot of people thought that slavery was a thing of the past, it was actually still going on in Alabama, and it was brutal. And the mining particularly was brutal because these were very primitive mines and send people in, and the mines would collapse. It didn't matter, just cover it up, call for some more convicts, and keep on doing the same thing. That was accompanied by lynching, which was going on. This was another way of maintaining white supremacy, of keeping the racial order as it always had been. These are the first picture there. Look at notice the little girl. Lynching was a family affair. This little girl here, she's watching the lynching. This is most people were hung, but some people were burned. This is a woman being hung. This is a lynching in Indiana, not in the South. This is lynching in Waco, Texas. 15,000 people showed up to see Jesse Washington. Just about everything imaginable done to him, including burning him to death. And it's interesting, when lynchings took place, everybody knew who did the lynchings. Often it was the most prominent people in the community. Often it was the judges and the prosecutors, the lawyers, the doctors, the other people. And yet nobody was ever prosecuted for lynching anybody. This is another failure of the court system, because the civil rights after the Civil War passed the Equal Protection Clause of the 14th Amendment that said every person was to get the equal protection of the law. That meant that the legal system would look out for everybody, not just white people. But as you can see, it failed to do it. It failed to do it in terms of protecting people from being lynched, and it also did it in terms of not punishing the people who did it. This was a flag that often flew outside the window of the NAACP in New York in the effort that was made throughout. And this is the 20s, 30s, 40s, during this period of time that this kind of racial violence. And it's interesting to me today, when we talk about terrorism, you talk about terrorism, this is terrorism. This was not only to lynch the person who was being lynched for whatever reason. This was to put fear in all the black people that you step out of line one iota, this is what's going to happen to you. You're going to be hung, you're going to be burned, you're going to be castrated, you're going to have all these things happen to you. And yet never did the Senate pass an anti-lynching bill. President Truman sent an anti-lynching bill to the Senate. Richard Russell of Georgia filibustered, used every procedure that he could to prevent it, and ultimately prevailed by saying states' rights, federalism, all these things we hear today about keeping the federal government out of what's going on in the states were the arguments used. And it really says something that we never passed a bill to prohibit lynching. We haven't to this day passed an anti-lynching bill. These are a couple of African-American lawyers who were in practice in Chattanooga, Tennessee around the turn of the century. You can imagine what it must have been to have a law practice if you were African-American in Chattanooga, Tennessee, right there on the border with Georgia around 1900. A fellow named Ed Johnson was convicted and sentenced to death there. His father came to Noah Pardon and asked him if they would take the case. His court-appointed lawyers had abandoned him after the trial, even though he had a death sentence and was going to be executed. And Noah Pardon goes to Stiles Hutchins and says, are we going to take this case? They had to know that if they took this case, nothing would ever be the same again. And Stiles Hutchins said, for those, much is given, much is expected. I can't imagine that much was given these two men. But nevertheless, they took the case. Noah Pardon took the train to Washington, D.C. Back in those days, that's what you did. He got before Justice Harlan, the first Justice Harlan, got a stay of execution, and that night, Ed Johnson was lynched. He was taken out of the jail there with the cooperation of the sheriff. He was taken down, if you've ever been in Chattanooga, there's a bridge that goes over the river that goes through town, and he was hung and shot over and over again. Right after that, after a minister's home was burned down and after their homes and their law office was shot up repeatedly, Stiles Hutchins and Noah Pardon left Chattanooga and never came back. They took on that case and they took on that cause, as hopeless as it was, and put everything they had on the line. And yet their client was lynched and they lost everything they had. There's a marvelous book about this by Mark Sheridan and Leroy Phillips called Contempt of Court, because the sheriff was held in contempt of court, although he only got a few months in jail for doing it. But I recommend it to you. As Dan Carter pointed out, the Southerners quickly learned that lynching was giving the South a bad press and were untidy. And as he said, they were increasingly replaced by the legal lynching. That is, taking people, telling the crowd, just hold off, and let us take him to court and let the system run its course. Everybody knew what the outcome was going to be. These cases were not contested cases. All white, all male juries, the Scottsboro case, I mean, just the history of these cases of people sentenced to death. One case in which the trial lasted just an hour, and they took the fellow out behind the courthouse and hung him right after it was over. And paper wrote an editorial and said, well, it was awful quick and it didn't seem very fair, but at least we didn't lynch him. So we made progress. But increasingly, the lynchings came into the courtrooms where we had just a perfunctory trial with somebody represented by a perfunctory lawyer, and the outcome was a foregone conclusion. And so we tried to cover this up a little bit by giving it a little procedure, having a judge, having a jury, but as I said, everybody knew what the outcome was going to be. Carter also points out they would beg people, don't just let the law take its course. But they said the result of this was that the law prostituted itself to the demands of the mob. And we really had mob rule, we just moved it in-house in the courtroom. Isabel Wilkerson writes, beautiful book, The Warmth of Other Suns, and that's all I'm going to say about Jim Crow, about what a rigid caste system it was. People weren't moving from the South to the North because of great opportunities or great to live in Chicago or New York or somewhere else. It was because literally black lives did not matter. That if you were a black person and you worked on a plantation and that planter didn't like something you did, he could shoot you dead and he didn't pay any price for it whatsoever. You looked at a white woman the wrong way, even as late as Emmett Till. I remember Emmett Till's case in my childhood, who was lynched in Mississippi in the 1950s. And people were fleeing this place where people were still being held in slavery or something very close to slavery and going to the north in this great migration of people. Well, I often say that the criminal justice system is a part of our society that's been least affected by the civil rights movement. A lot of things have changed. We have African-American legislators, county commissioners, school boards, all that. My congressman was almost killed at the Edmund Pettus Bridge, but now John Lewis is one of the most respected people in the Congress of the United States. But you go to the courthouse and nothing's changed. You go to the courthouse and you still have the white judge, the white prosecutors, the white court-appointed lawyers, and even in communities with very substantial African-American populations, you still have all-white juries. 95% of the prosecutors, we've had a lot of attention here lately to law enforcement. Two things have helped us learn a lot about the criminal justice system. One, DNA, and second, cell phones, or the other surveillance equipment that's out there. We know from DNA that a lot of people that have been convicted and sentenced and put away for a long time were completely innocent of the charges. We just had Kurt Bloodsworth at Yale a couple of weeks ago, who was convicted and would have been executed had it not been for that teeny semen stain on the clothes of this little girl who was brutally killed that showed that he did not do the crime and that somebody else did do the crime, and who that person was that did the crime. We know from cell phones that when Walter Scott was shot, he was running away from the police and he was shot in the back. We would have never known that if there hadn't been a cell phone picture of that going on. So we know more today than we used to know before about what's happening in the criminal justice system. But those are what's happening outside in law enforcement and the law enforcement relationship. What happens inside is all these discretionary decisions, almost all made by white people, about do we have bond, do we not have bond, do we charge a serious crime or a less serious crime, do we not charge at all, do we dismiss the case, do we charge in federal court or do we charge in state court? All those decisions being made by prosecutors, 95% of whom are white, 73% white men. And I can tell you from my experience, of those 73% white men, many of them are mean white men that make those decisions, and they're made without any judicial review. There's no judge looks at it. These are these charging decisions, whether to seek the death penalty, because no case has to be a death penalty. There's no mandatory death penalty. A crime takes place and the prosecutor decides, first of all, whether to seek the death penalty. Most prosecutors never seek the death penalty, something a lot of people don't understand. The majority of the death sentences in this country and a majority of the executions come from 2% of the counties in the United States. And that's because of the prosecutors. Harris County, Texas has executed 123 people, just one county, 123 people. That's more than any state except obviously Texas, which has executed over 500, and Virginia, 110, and Oklahoma, 111. So Harris County has actually executed more than these other states that are over, and no other state is over 100. And it's all because of the prosecutors. Because you had very aggressive prosecutors in Houston. Johnny Holmes, first of all, is sort of classic Western prosecutor with a handlebar mustache who just made it his thing to seek the death penalty. And then the judges accommodated him by giving him, assigning people very poor court-appointed lawyers to represent them. 3 cases in Houston, the lawyers actually slept during the trials of death penalty cases. One case, the George McFarland case, the reporter asked the judge, Doug Schaefer, how can you preside over a case where, a death penalty case where the lawyer's sleeping, he was snoring. And Judge Schaefer said, well, the Constitution guarantees everybody a lawyer, but it doesn't guarantee them that the lawyer has to be awake. That's what we call a strict constructionalist, if ever there was one. But it's no laughing matter as in that case or any others. I'll tell you the power of prosecutors. This is Kelly Gissendaner getting her degree from a theological seminary in Atlanta. We put her to death a couple of months ago. 20 years ago, she and her boyfriend, she was having an affair. She was married. And they decided, as happens with unfortunate frequency in our society, they decided they were going to run off together and they would kill the husband. And they did. The boyfriend took the husband out, killed him, stabbed him to death. Ms. Gissendaner is nowhere near where the murder takes place. And there's no question that she helped plan it. And under the felony murder rule, she's responsible for it. But the boyfriend, of course, is the one who actually drives the knife in the guy. He's got blood all over him. And what does he do? It's what always happens. He goes to the prosecutor and says, I'll testify against her if you don't seek the death penalty against me. Of course, they had a good case against him. They could get the death penalty against him, but they may not be able to get it against her. So he agreed and he took the deal. Now, they actually offered her a deal as well. They said you could have life imprisonment plus 20 years, but her court-appointed lawyer told her not to take it, which was terrible advice. She didn't. So she was sentenced to death. Went to trial and sentenced to death. 20 years later, it's time to kill her. And 20 years later, the guards that work at the prison there are saying, this woman has had such a beneficial impact on our lives and on the lives of our children. And then other inmates say, you know, this woman has been just a positive influence. She's helped us in so many ways during the time she's been here. She's gone off to theological seminary and gotten a degree. It's not really, when you think about it, I mean, Hillary Clinton was saying at the debate when she was saying what kind of death penalty she supported. Well, she supported the death penalty for somebody like Timothy McVeigh, who blew up the federal building. This woman didn't blow up the federal building. There's no question she shouldn't have killed her husband, but she is not one of those people whose crime was so horrendous that we say it can only be punished by death. And she is certainly not an offender who's been given chances before, whatever. It was the only crime she ever committed. The only person she was ever a danger to was her husband. They tied her down, and she sang Amazing Grace, and she got through the first verse, and she got about halfway through the second verse before the lethal drugs took her life. You just wonder, is this really what we want to be doing? I mean, a couple of other people. We were executing, Georgia is executing 2 people a month now. These are all people sentenced to death back in the 80s and 90s. This is Robert Holsley. He was executed right at the end of 2014. He was represented at his trial by a lawyer who, during the trial, was drinking a quart of vodka every day. Now, if that doesn't mean anything to you, I will tell you a quart of vodka is 21 shots of vodka a day. Next time, before you take your finals, try drinking 21 shots of vodka and see how well you do. He also was fairly preoccupied by the fact that he was about to be indicted and disbarred, and indeed was ultimately imprisoned for stealing funds from his clients. So he wasn't exactly focused on Robert Holsley's case. And he never put on evidence that might have been of interest to the jury that Robert Holsley was intellectually limited, that he had suffered abuse during his childhood that was so outrageous, so notorious, and so well known that the people who lived in the neighborhood where he grew up called his childhood home the torture chamber. But that never was heard by the jury. They might have spared his life if they had heard it. This is Warren Hill. I knew Warren for a long time. You didn't have to spend but a few minutes with Warren Hill to know that he was intellectually disabled. He was like a child. 9 different psychologists examined him, and they all concluded that he was intellectually disabled, what we used to call mental retardation. Theoretically, you can't be executed if you're intellectually disabled, but he was. Brandon Jones, 72, executed just last February. Again, we're executing a lot of people fairly old who are getting put to death. And also some other people that are worth mentioning. Kenny Falsa, we just executed just last month. This was a case in which they found out the jurors had referred to him with a racial slur, called him a nigger. So did his defense lawyer. It didn't keep him from being executed. I've got my things in the wrong order here, but I'm going to go up here and get Glenn Ford if I don't have Glenn Ford. At any rate, Glenn Ford spent 30 years in Angola, Louisiana State Penitentiary, on death row for a crime he didn't do. And when he came out, the man who prosecuted him was a fellow named Marty Stroud. And he wrote this. This is from a letter that he wrote to the editor of the Shreveport paper, in which he said in 1984, when he tried Glenn Ford's case, he was 33 years old. He was arrogant, judgmental, narcissistic, and very full of himself, like so many prosecutors are at age 33, not to mention other people as well. He said, I was not as interested in winning in justice as I was in winning. But he now recognizes that he was making decisions that could have led to the execution of an innocent person. Glenn Ford was represented by 2 lawyers who had never tried a case. One lawyer was an oil and gas lawyer. The other lawyer was a slip and fall lawyer. And those are the lawyers that he had at his trial. And then Marty Stroud struck all the blacks from the jury in jury selection. And as a result of that, Glenn Ford was tried by an all-white jury and, not surprisingly, sentenced to death in Shreveport, Louisiana. And as I said, spent a little over 30 years in prison. Ruined his life. When he came out, he had stage 4 cancer. He died within a year of being released. Marty Stroud concluded that no one should be given the power to make this decision about whether people live or die, particularly people who are politically ambitious or ambitious in other ways. This is Anthony Ray Hinton with my friend Brian Stevenson. Again, 30 years on death row in Alabama for a crime he did not do. 18 years ago, Brian had ballistics tests from the lead ballistics examiner at the FBI, as well as 3 other experts, to show this man did not fire the bullets, that his gun was recovered from his mother's house, that he was completely innocent. We had him come and speak at Yale this year. I had him come in January, and because I thought it would set off a nice start to things. You can see how people appear in court, dignity, wearing these prison stripes, handcuffed, chained. This is a man who's innocent, and he appears in court like that. There he is when he got outside, and he looked more like he did. These are the people, now we have 60 years. I mean, here 30 more years. Now we're up to 120 years. These are 2 innocent people. Henry McCollum, who's on the left here, and then his half-brother, Leon Brown. Both of these men are intellectually disabled, very intellectually disabled. They were convicted of a crime of murdering a child. Of course, nothing worse to be in prison for having murdered a child, and people thought you did it. They didn't quite know what was going on. They had to put Henry in solitary confinement whenever there was an execution, because he got so upset and so carried away because of what was going on. They finally did a DNA test that could have been done, or at least in the prosecution's file, there was a note, check this fingerprint that was lifted from the scene with a certain person. They did the DNA tests, these guys were not the people who committed the crime. It was this fellow that they had talked about getting the, they never got around to doing the fingerprint comparison. So basically ruined their lives. For the cases that go to trial, and not a lot of them do, because 95% of all criminal cases are decided by plea bargains. They're decided by plea bargains, and the prosecution has tremendous power. The power to say to somebody, we are going to put you on death row unless you take this deal. I don't know how many times I've heard that. How many times I've heard prosecutors say, I want to kill your man. You better tell him that he better take this deal or he's going to ride that lightning bolt. That was back when we had electrocutions. It's a lot of power to coerce people into pleading. We've had a lot of innocent people plead guilty to avoid the death penalty, just as we have people plead guilty to avoid life imprisonment when they can get 5 years. But at any rate, as I said, prosecutors have tremendous power in this, and the reason that we still see in communities that have, as I said, very substantial number of people of color in the community, while we see all white juries, is that as juries are struck, each side has a certain number of peremptory strikes. Each side gets to strike usually 10 people in Georgia, and different numbers in different states. And what has been the practice for as long as we have had criminal courts has been that the prosecution strikes all the people of color. In part of the country I'm in, where it's pretty much black and white, all the African Americans, and that's why we end up with an all-white jury. Supreme Court said a few years ago, 1986, in a case called Batson versus Kentucky, we can't strike on the basis of race. Can't strike on the basis of race. You can strike for any other reason. Before that, they had said you couldn't strike on the basis of race. They said you can strike for any reason: religion, race, gender, don't like the way the person looks, what their job is, you can strike for any of those reasons. Now they said not race, and later they said not gender. But how do you know whether the prosecution, when they strike people of color, are striking them because of their race or for some other reason? And the court said, well, you've got to give, if that happens, if you strike all the people of color, then you have to give reasons for it. And so the prosecutors will strike all the people of color, the defense will object, and then the prosecutor will give his reasons. Oh, I didn't strike that person because they were black. I struck that person, and give a reason. This is one of those times in the court system when everybody knows what's going on. Everybody sees the corruption of the system. The prosecutor knows why he struck that person. He struck him because of his race. The people sitting in the audience know that. The defendant knows that. The jurors know that. Everybody knows, but we go through this pretense where he says, oh, you know, while I was questioning him, he looked down at the floor. And so I struck him for that reason. Or he works at a gas station, and I don't want anybody who works at a gas station on this jury. And the judge then has to make a decision, and the judge, of course, works with this prosecutor all the time. The judge has to decide, was this intentional race discrimination? Did the prosecutor strike this person because they were black? And secondly, did the prosecutor lie about it by giving a false reason for the strike instead of admitting that it was because of race? Now, how many judges do you think are going to make that finding? Particularly when, you know, the prosecutor, well, a lot of our judges used to be prosecutors. They used to strike all the blacks themselves. Now they've moved up to be judge. Their chief assistant is now the prosecutor. These guys go fishing together, hunting together. Soon enough, this prosecutor will become a judge and his chief assistant will become. The fact of the matter is this has failed rather miserably in terms of preventing strikes. The case out of Alabama just, well, a little while ago now, the prosecution, 21 strikes, 21 African Americans struck. The court said he had a race-neutral reason for every strike. Now, if you really believe that, my friends, if you really believe that you exercised 21 and only 21 strikes, and all those 21 strikes are against 21 black people and not a single white person, if you really believe that, well, you probably believe just about anything. In one case, at first it was in Florida, and then went to the federal courts. The prosecutor said the reason he struck the young woman, black woman, and said, well, she was a young black woman and the defendant was a young black man. Now that's obviously not a race-neutral reason. He had obviously not gotten, that prosecutor didn't get the memo. But he didn't stop there. He said, but in addition, when she answered questions about the death penalty, I didn't think she was real strong on the death penalty, so I struck her for that reason. Oh, okay. Well, the first reason wasn't okay, but the second reason was. I don't know. You know, we allow a certain amount of arsenic in our water and a certain amount of roach parts in our cereal, but how much race do we allow in selecting a jury? When a prosecutor says one of the reasons I struck was because she was a young black woman and he's a young black man, but I also had another reason. And the court said, well, as long as you have a good reason, we'll overlook that. One court said, you know, surely to goodness, every prosecutor gets a list of handy-dandy race-neutral reasons when they become prosecutors. Actually, they do. We found the ones that they've gave prosecutors in Texas and another one in North Carolina, in which they actually give you the reasons to give for striking the jurors before you've ever seen the jurors. Of course, the reason you're supposed to give is the actual reason for giving. But instead, you just look down at your sheet and it says, lack of eye contact. Your Honor, I struck that person because of lack of eye contact. Air of defiance. Boredom, that was the one that would get me. I've picked a lot of juries and I've yet to pick a jury where the people were riveted by the jury selection process. I tell you, it's pretty boring. But the thing about those reasons is, of course, there are these demeanor reasons. You don't know whether they're true or not. They may not be true, but nobody knows because you've gone through, you know, 60 people, and he's saying number 21 when you went through this person as the 21st person. Well, let me just give you one example of this. I've got a case actually that is before the Supreme Court of the United States. Timothy Foster is a young man I represent, sentenced to death in Rome, Georgia. 4 black people in the jury pools, but the prosecutor struck them all. We filed a Freedom of Information Act request to get the prosecution's files, and they forgot to shred their notes from jury selection. So we saw what they said. Every now and then, you kind of pull back the curtain and see what's really going on. Right after the Supreme Court in Batson versus Kentucky said you're not to strike on the basis of race, a prosecutor in Philadelphia stood up in front of a whole room full of young prosecutors and said, here's how you strike jurors, and it was all on the basis of race. The Supreme Court had just decided this. He didn't say, no, you can't strike on the basis of race. He said, and when you're talking to the black people, be sure to write it down, make a lot of notes, ask a lot of questions, because you're going to have to give some reasons at the end for why you struck those people. And it can't be race reasons, they've got to be other reasons. As it turned out, there was a videotape of that, which later came to light. And suddenly we saw something we didn't know before. We thought they were striking on the basis of race, but now we know good and well that they were striking on the basis of race. I have to hit this. This was, there's a list, and this went on for about 5 pages, of all the people who were summoned for jury duty in this case. All the black people have a B beside their name, and they're highlighted in green. There's a key at the top of the page on each page that says green indicates black. And these were circulated around, these race-coded juror lists were circulated around the whole prosecutor's office to come up with reasons. This is Eddie Hood, one of the jurors. You can see the only thing on his jury questionnaire that was of great interest to the prosecutor was his race. This was the way that blacks were listed. B1 was Eddie Hood, B2 was Ms. Louise Wilson, B3 was Corrine Hines, and so forth. So there seemed to be an interest in blacks here. They ranked the prospective jurors against each other. And they had in their notes there, well, Ms. Harge might be the best one to put on the jury. If we had to pick a black, maybe it would be Ms. Garrett. And then the DA says Ms. Garrett had the most potential out of the blacks. So the blacks and the whites have been separated out and treated differently, and they're thinking maybe they might have to take a black. But the fact of the matter is, Ms. Garrett was never going to be on this jury, because there's a list here of definite no's. These are the people that are going to be struck. They've got 10 strikes. These are 6 people that are going to be struck no matter what, and the first 5 are African American. Miss Garrett, right there, number 4. She ain't going to be on this jury come hell or high water. It's just not going to happen. And the only white person is Ms. Grinstaff down here at the end. She was so opposed to the death penalty, the judge should have excused her, but he did not. And then this is it's hard to see here, but it says right up here, Church of Christ. And then it says, doesn't take a stand on the death penalty. Each person makes up their own mind. The prosecutor gave as his reason for striking Mr. Hood, B1, that he was a member of the Church of Christ, and that the Church of Christ was adamantly opposed to the death penalty. His own notes, obviously he had checked out the Church of Christ and found out that that was not the case, and yet he still made that representation to the court, just a bald-faced lie. Oops. Well, and I don't have my last slide, which was the closing argument that the prosecutor made, which was to the all-white jury to return the death penalty against Tim Foster to deter people out there in the projects. Tim and his family lived in the projects. 90% of the people that lived in the projects were African American. That case has been pending since November. It's been argued since in early November before the Supreme Court. But my point is simply this, that if you're given an incompetent lawyer, a lawyer can't even stay awake during your trial, if all the people of color are struck, if all the decisions are being made by white people all the way through this process and all these things that I've talked about, this is not a fair, impartial determination of guilt or punishment. It's rigged. It's simply rigged. I mean, I got a call from a newspaper reporter in Pennsylvania, and she said, I just found out that 1/3 of the lawyers that handled death penalty cases in Pennsylvania have been disbarred, convicted of crimes, or suspended from practice. And I said, you go to any death penalty state, you'll find the same thing. And she said, well, how could that be? Why would the most serious cases of life and death, why would they be that that you would have what looked like the worst lawyers representing them? I said, because it's rigged. It's rigged. People are given a lawyer. You're given a lawyer who doesn't care anything about you, given a lawyer who's a racist, given a lawyer who doesn't do the investigation, given a lawyer who doesn't have the time or the inclination even to represent you, and you're going to end up on death row. People say, why does Texas have so many people under death sentence? You get accused of the death penalty, you get a court-appointed lawyer who is a walking violation of the right to counsel, you get the death penalty, then you're assigned an even worse lawyer. And you can go through the system very fast. That's how they've killed about 550 people in Texas. This is not just true with regard to the death penalty. It's true with all kinds of crimes in this system of ours. And it's something that is a matter of great urgency that we deal with. That people have quality representation from people who have integrity and the ability to do it, and that I don't know how we're ever going to do it, but that we make as the highest priority eliminating this scourge of race discrimination we've always had. And if we're not careful, we're always going to have it until our inattention to global warming brings the whole show to an end. Thank you. And if there are any questions, I hope I didn't use up too much of my time there.
A year ago, several of us went on a civil rights seminar led by Julian Bond. He came here to speak, and we found out that for several years he's been doing week-long seminars sponsored by the University of Virginia. And several of us went with him. Now, looking back, it was a blessed experience to spend that week with him. We started off with Andrew Young and John Lewis the first night, and we went on to Montgomery and spent time with Brian Stevenson at the Equal Justice Initiative. And we were all completely wrung out by the end of the experience. And one of the reasons is that one of their first initiatives was to stop children from getting the death penalty and life in prison, 12, 14-year-olds. And of course, they had to take it all the way to the Supreme Court, and they have achieved that. But I guess you know, but then when you really hear, it's unbelievable. And some of them were white and black. I mean, there was a woman who was sentenced to death. She had her third child, couldn't get to the hospital in time. The child was stillborn, and they convicted her of murdering her child. And she was sent to prison for 10 years or something like that, and they did get her out. But it's a staggering experience when you go down and speak with the people who are in the trenches fighting for these things.
Well, unfortunately, I think the criminal justice system is sort of out of sight or out of mind for most people. All the people coming through the criminal courts, just about, are poor. The vast disproportionate number are people of color. And for the average middle-class person or upper, certainly the upper 0.1%, it just doesn't register. Nobody has any idea what's going on. That's why it's so important that people pay attention and go to these courts and see what's happening in the trenches. I mean, it's interesting with regard to this process that I was talking about for dealing with racism and jury selection. Thurgood Marshall, who of course had been there, who had tried death penalty cases, had tried in Groveland, Florida, had tried death penalty cases, had gone out to Hugo, Oklahoma and tried death penalty. He said right then, it's not going to work. He said any prosecutor is going to be able to give reasons for striking people. And this is going to go right on. He's exactly right. That's what's happened. And so we still have that. And yeah, there's a tremendous amount of cruelty in this system. Now the Supreme Court has said you can't give the death penalty to anybody under age 18. But historically, George Stinney was 14 when he was executed by the state of South Carolina. He was so small that he had to sit on some books in the electric chair, and the uniform was kind of falling off of him because it was so big, or the jail clothes. But they electrocuted him nonetheless. So yeah, it's a brutal history. And a lot of people want to say, well, that was yesterday. None of this makes any difference today. Now we're all enlightened and we're not racist and we're not whatever. I don't think anybody thinks that anymore after the last several years in this presidential campaign. But people were saying that until it became too obvious to deny. But we have to look at this history. This is all tied into history. And it's impossible in many ways. Now we have children. Of course, the other thing Brian's office fought was children getting life imprisonment without any possibility of parole. And the Supreme Court said you have to at least have the possibility. You can still do it, but you have to at least consider their youth and do it. And one of my colleagues, Siasane, has been going around representing children. I mean, she's been getting 65-year-old men out who were 13 when they were sentenced to life without parole. One of my friends last week just got Gary Tyler out. He was sentenced to death as a child when the Supreme Court said you couldn't do that. He got life without parole, 41 years. He's 41 years, and walked out of prison finally, out of Angola. So there are many, many, many issues with the criminal justice system. Yes.
So given all the problems that we've talked about, where it's like there's racist laws, there's racist enforcement, and then there's racism in the system itself with the prosecutors, the judges, and the juries, how do you think is the first way we should go about tackling this problem? What do you think is the most effective thing we can do to actually make a difference?
Well, you mean the people sitting here in this room, or
either the people sitting here in this room or on a larger national scale?
Well, I mean, I think people like Atia Holly who've come down and who've taken this on and are in the trenches and are doing it. I think what so many people, I mean, the reason I went to the South, I was a public defender in Washington, D.C. I had a very good job. I liked living in Washington. I got a couple of death penalty cases. I saw how terrible the lawyer was in the first case. I saw how racist the judge was in the second case. And I just decided that, you know, I couldn't handle all these people, but I could at least help out on as many cases as I could. And so we set up a little beachhead and started representing people. And then we got this Harvard law student, Brian Stevenson, came down and got him interested in it. And then he came to work for us and then went off and established EJI. And my view is if we can just keep doing that and just keep bringing people into it, the question for people accused of any kind of crime is whether they're going to have a lawyer who's going to lay it on the line for them, who's going to do everything they can, who's going to zealously defend them, which is what they're entitled to, or whether they're just going to have somebody who can't get a job anywhere else and is working 9 to 5 at the public defender office processing people through. I mean, in the place where Atia found the guy in jail, we would go to the courthouse there and they'd bring these people in and they would meet a lawyer. This is the first time they've been in court. They'd meet a lawyer for 5 or 10 minutes. Then they go before the judge, plead guilty. The judge would sentence them, and that was it. That was all the time they spent with a lawyer, and that was all the time they spent in court. So there was no attention being given to their case whatsoever. They didn't even have an interview with a lawyer. They just had a lawyer tell them, here's what the plea offer is, and if you don't take it, something terrible is going to happen to you. And that still happens. I mean, that's still happening right now, all across this country.
The problems that you talk about leading to unfair enforcement of the death penalty, like the racially biased peremptory striking and the lack of oversight for prosecutors, sound like pretty hard problems to solve. Have they not been solved because there are too many political obstacles and the system is too hard to change? Or even if you were in charge of everything, would you still not know exactly how to solve all the problems we have?
No, I mean, you know, you got to remember in the state courts, except for, as I said, except for up here in New England, everywhere else the prosecutors and judges are elected. It's not a legal system, it's a political system. And the prosecutors are looking to move on to be judges or to be attorney general, governor, senator, whatever it may be. So they're using these cases for their own political advantage. And if they can, you know, death penalty cases, the prosecutor's dream come true because you get a lot of TV time on those cases, although not as much anymore, but used to be. But the reason it doesn't change is because everybody has their little fiefdom. I mean, like in Georgia, we have 49 judicial districts. Each one has a prosecutor and a judge. There's no requirement that the prosecutors all have the same policies. Prosecutor in one district may never seek the death penalty. He may think it's law enforcement quackery. Some of them do, I mean, they've told me. Other prosecutor may seek the death penalty every opportunity he gets, like Johnny Holmes did in Houston. So everybody's operating their own little fiefdom, completely separate from everybody else. This is no public policy here. This is just what is politically expedient for these prosecutors at this time, and nobody wants to give that up. I mean, Sandra Day O'Connor, since she left the Supreme Court, has been in a campaign to eliminate judicial elections, because the judicial elections have gotten so much. Now you see people running for judge and you think they're running for sheriff, because all of their ads are about how many death penalties they've upheld, how many child molesters they put away, how many, I mean, all of this stuff, and huge amounts of money spent on this. And obviously the judges that you get are going to be pretty, you know, pro-prosecution judges. She hadn't gotten anywhere. I mean, I admire what she's done, and I've written about it myself, and I've tried to advocate it. Nowhere. Everybody wants to elect their judges and wants to elect their prosecutors, but you look at a place like, you know, I spent some time in Connecticut, and there the people are civil service people, and they're chosen by merit. No system's perfect. I mean, no system's perfect, but if you have a person who's more of a civil service type person, and of course if you look at the European model, the idea of electing these people is just, you can't imagine what you're thinking about. You have a unified system where you have a chief prosecutor, attorney general, whatever, and then you have a staff of professionals who follow the basic policy guidelines that person sets, throughout the country, if you're in France, Germany, or Denmark, wherever it may be. But that would obviously be a better system, and that, the system should be reasonably consistent. I mean, there are going to be some differences in people and crimes and all that, but the system should be reasonably consistent, and it's not at all now. It's just as Stuart said, it's like being hit by lightning. What happens to you and where you are. Geography means more than almost anything.
Hello. Do you think a solution would be getting rid of peremptory challenges altogether?
Yeah, I think that's the ultimate, as a lawyer who loves to have peremptory challenges and can't imagine not having them, and can't imagine leaving who's on the jury up to the judge, who's always against me. But the fact of the matter is, if we're serious about eliminating race discrimination, we've got to get rid of peremptory challenges.
I have another question, if no one else. Do you think that the issues with assistance and effective assistance of counsel has to do with law degree or law schools just giving out degrees to people that don't deserve them?
I don't think that so much. I think it's what Robert Kennedy said: the poor person accused of a crime has no lobby. There's no incentive for governments that are trying to fine or imprison or execute people to give them lawyers to defeat that purpose. You give a lot of money to the prosecution, we get billions of dollars to prosecution, billions of dollars to the police. I mean, they don't know what to do with all the money. Down there in Ferguson, they had all that, military equipment or whatever. It's like all these police departments, they don't know what to do with all the federal money that they've been given. On the other side, it always seems like there's never enough money for the defense. We just don't have enough money. But I've never seen a case yet where there wasn't enough money to prosecute the case. There's always enough money to prosecute the case. But, we have public defenders handling like 300 cases at one time. You can't even know all your clients' names, let alone know what's going on with regard to their cases and so forth. And I think that's partly intentional too, because as long as you have a fairly inadequate system of providing representation, whether it's overworked public defenders or whether it's court-appointed lawyers who are getting paid such a small amount that they have to spend very little time on each case, or contract lawyers who contract to represent a whole bunch of people for a fairly small amount of money, so they can't spend much time. All of those make it more likely the prosecution is going to prevail, because there really is not going to be an adversary. There is no adversary system. In many places, not everywhere, but in many places, there just simply is no adversary system. The prosecution just comes and does whatever it wants to, and particularly with the death penalty, with mandatory minimums, repeat offender papers, things like that, the prosecution can really tell you, if you don't take the deal, you're going away. I mean, I had a young woman write me several years ago now, and she was facing arson charges. And she said, my public defender wants me to plead guilty, but I'm not guilty. My apartment burned up, everything I had, all my yearbooks, everything I had, I had nothing but the clothes on my back. And 6 months after this happened, she gets charged with arson. And she said, I'm homeless, I'm living in my car, I've asked to be put in jail because I'm afraid I'm going to die from the conditions of being homeless. I mean, this is how desperate people are. And so I took her case, and I looked into it, and I found out that that public defender office, they could put down guilty pleas, but they didn't have a lawyer in that office who could try an arson case. Arson case is very tricky. Todd Willingham was executed in Texas because the arson people didn't know what they were doing. Whether a fire starts accidentally or whether it started on purpose, there are a lot of mistakes made in doing that. So, of course, we were able to confer with some of the, well, with Jack Lentini, who's a leading arson expert in the country. We went down and presented what our findings were to the prosecution. He dismissed the case. But I tell you, when I was representing her, it was just like having a death penalty case. I mean, her whole life hung in the balance. In fact, one of the things she said in the letter to me, she said, they keep telling me to plead guilty, and I keep telling them, I am never going to plead guilty. I don't care how long I have to spend in prison, because if I plead guilty, I will never be able to get my nursing license, and nobody will ever take me seriously again. And I thought that's remarkable. I mean, she even knew what the collateral consequences were. And she's determined to be a nurse. And she has been ever since we got that case dismissed. But she couldn't get a job. She said, I can't get a job with these charges pending. I can't get the case resolved because I'm not going to plead guilty. And the case just kept getting passed on to the next time. It had been pending 3 years when I got involved. And we got it dismissed in about 2 months. But there was nobody to help her. Yes, sir. Yes, ma'am. Yes. Ma'am.
What would you think of the possibility of bringing, public defenders work very hard and have no money.
That's right.
But they are not living up to their ethical obligations of representing their clients. Is there any way for the legal profession to put pressure on the public defenders to say, we are not going to pretend that we're providing the counsel that people are entitled to?
Well, some public defenders are doing that in New Orleans, where they've cut back so much on the funding for the public defender office. That's what they're doing. They're just saying, we cannot represent the people. Somebody comes in charged with a crime, they say, we'll put your name on a list, we'll get to you when we can, but we can't get to you for maybe months before we'll be able to get to you. Judge Hunter just recently dismissed 200 cases. He said, if you can't get the people lawyers, we're going to dismiss the cases. I mean, that's all you have to do. But our judges don't have the guts to do that. There are very few judges that have the guts to do that. And quite frankly, there are very few public defenders that have the guts to do what they're doing in New Orleans, which is too bad. Because, people call me, they ask me what to do. In Louisiana, they cut the budget for representing poor people accused of crimes from $33 million to $12 million. Well, it's a joke. There's no way they can do it. I say the only thing you can do is refuse cases. That's all you can do. You represent the number of people you can and refuse cases. But the bar doesn't, even the most gross incompetence, the sleeping lawyers, the drunk lawyers, all that, the bar doesn't do anything to these people. They're representing people in the next case. The bar's chasing after people who steal money from their clients. But that's about all the bar has. They just unfortunately have very small enforcement mechanisms with the bar.
So you mentioned that the prosecution will essentially claim with absolute certainty that they would be able to put away a defendant for life if he doesn't take a plea deal. And do you think this conviction and absolutist kind of rhetoric comes from the incompetence and disinterest of the defense, or relative to the prosecution, or the lack of a check from the judge, who you mentioned often has a relationship with the head prosecutor?
Well, I don't know. I didn't mean to imply the prosecutor's going to say, I think every prosecutor thinks they're going to get a conviction if they take the case to trial. I don't know about the certainty part, but they think they're going to. The reason that you have pleas is it's all risk assessment. If you go to trial, if I'm your lawyer and I look at the prosecution's case and I say, yes, if you go to trial, I want you to understand there's not going to be any people from your community on this jury. It's going to be an all-white jury. And the prosecution's going to get all the people who have any reservations about the death penalty off the jury during jury selection. And so here's what the prosecution has. And I'm telling you that the chances are quite substantial that you will, first of all, you will definitely be convicted, and quite substantial that you'll get the death penalty. So if you want to go to trial, by golly, we'll go. But they're offering you usually life without parole. The best you're going to do at trial is life without parole. So you may want to take it rather than take a risk of getting the death penalty. The problem is when you have people who are not guilty and you know, have to decide whether or not they're going to plead nolo contendere or something like that and still get sent away, or whether they're going to go to trial. Because, you know, innocent people get convicted. I mean, we've had, I think, Anthony Ray Hinton up here, I think was the 152nd, I believe, person exonerated from death row. That's a very bad error rate. 152 people who were completely innocent, who were sentenced to death. And then, of course, we've executed at least Todd Willingham, who was innocent, Carlos de Luna, who was innocent, some other people who were arguably innocent. So, you know, those are the people that have the toughest choice in these cases.
And one more question, if that's all right. You mentioned in the lunch conversation earlier today that how a judge who doesn't enforce the death penalty is often voted out in the next election cycle. And have you found that these elections have had strong voter turnout with people who have knowledge of these decisions, or are these elections largely controlled and won by various interest groups and pro-death penalty interest groups?
No, it's not pro-death penalty. The judicial elections are between the Chamber of Commerce and the business community and the plaintiffs' lawyers. The Chamber of Commerce wants all kind of caps on punitive damages and things like that. Of course, the plaintiffs' lawyers don't want that. They want class actions. The Chamber of Commerce doesn't want class actions. They're all about money. But that doesn't get the public's blood boiling. What gets the court's blood boiling is to say, Justice McGraw let a child molester out. Justice McGraw let this kid, what it means is Justice McGraw was one of several judges on the West Virginia Supreme Court who said that there was a legal error in a case involving child molestation and said the case had to be tried again. But it's not characterized that way in the ad. It's that, you know, Judge McCraw said by the time that election was over, he said people thought I was the child molester. But just recently, Ohio had an incredibly expensive Supreme Court race with two members of the court running for re-election. One was named Judy French, and she was running ads about Judy French has voted to uphold all these child molestation, all these death penalty cases, all these. It was, as I said, it was like she was running for sheriff. And then 5 days before the election, she hands down an opinion for the whole court upholding the death penalty for a black guy who's convicted of killing a white police officer. 4-3 opinion. It's not one-sided opinion. This is this is 5 days before the election. So it basically uses her job as a justice on the court to rally voters for her. I can't believe she did it. It's unconscionable. I mean, she should be removed from the bench for doing it. And I can't believe the other members of the court did it. But but they're all Republicans, and she's a Republican. And so this was to help out. I mean, we had a case, somebody sent me a transcript of a case where a judge was supposed to preside over a death penalty hearing in a case, and he called the lawyers up to the bench and said, well, we're going to let Judge Shake preside because he's on the ballot Tuesday. I mean, here's this death penalty case. You're going to bring the judge in so he can preside just to get on TV because it was a very highly publicized case. So that's the way these cases play out. But the big money comes from plaintiffs' lawyers, and the amount of money, I mean, you can go online and read some of the articles about it. I mean, the amount of money, particularly after Citizens United, the decision by the Supreme Court that, corporations can give money and all that, I mean, it's just completely out of hand now. And the days when a highly respected lawyer would go on a state court or go on a state Supreme Court, very, very unlikely now. That's a bad thing about it. I mean, you don't get good judges when you have a system like that. People don't want to be taken out. Yes, ma'am.
Do you have any predictions on the outcome of the Foster case based on the oral argument?
Well, based on the oral argument, it went pretty well, and we thought this was what's the outcome of the case that I put up here on the board. There's no use speculating because you just don't know. I mean, it seemed like everybody on the court realized that this was blatant race discrimination. Judge Kagan's first question to the lawyer from Georgia was, isn't this the clearest violation we'll ever see? So that was, from my standpoint, that was pretty encouraging. But that doesn't mean that she's got all the other justices on board. I don't know. I just really don't know. If they don't, it will really say a lot about, because this is just absurd. And if they don't, it will really say that the court is just doesn't care. I mean, it's amazing. The court cares so much. We don't want race to have any influence on whether Ms. Fisher is admitted to the University of Texas. If there's even a scintilla of race taken into account in admissions to college, there are a lot of justices on the court that it just drives them up the wall. But we can have blatant race discrimination when it comes to eliminating black people from serving on juries. That doesn't square to me. But that's where Justice Roberts and Alito and Thomas, come out on these things. So we'll see. If there's not one more question, I want to thank you all very much. I appreciate you coming, appreciate you staying. Thank you.